Hello friends, my name is Atul. Welcome to my channel. So I hope the past videos were useful for you and you were able to send those videos or send those links to maximum people so that everyone can be benefited. If you are new to the channel, then please subscribe to my channel and please hit the bell icon. So without wasting any time, let's get started. 1.06 Nature of Standby. So what it says, suppose we have a transaction. Applicant gave a request to the bank issued the SBLC. So in this case, bank X is the issuer, A is our applicant, B is our beneficiary. Now this standby which was issued, the basis of this standby was this contract which happened between applicant and the beneficiary. So 1.06 part A says that the standby is irrevocable, independent, documentary and binding. These four words we'll see individually in the subsequent articles. So first is, a standby is irrevocable. Irrevocable means it cannot be amended or cancelled without the consent of the beneficiary. This consent is required for amendment of the standby or if the standby is to be cancelled, unless the standby in its text mentions an auto extension clause, auto amendment clause or automatic cancellation clause. So for example, so the SBLC mentions the condition, this SBLC will expire after 10 days from the date of submission of certificate from XYZ. This is a condition wherein the SBLC will automatically expire once a certificate is presented from this entity. This will not need beneficiary consent for cancellation, because when beneficiary accepted this SBLC, this condition was an integral part of the SBLC. So in this case, the SBLC will be cancelled by virtue of this condition being an integral part of the undertaking. This is what is meant by this undertaking is irrevocable in nature. Let's look at the second point. Okay, the same example. Now ISP says a standby is independent in nature. Independent means what will happen if a claim is lodged by the beneficiary under the standby. By lodging claim, I mean beneficiary has submitted SBLC complying documents to the issuer and issuer will make payment. So beneficiary will submit documents, issuer will pay to the beneficiary. This payment, once issuer makes the payment to the beneficiary, the next thing what issuer will do is ask for reimbursement from the applicant. Now by independent we mean that this payment is not dependent on the fact whether this reimbursement is coming or not. This payment is independent of the fact whether beneficiary claims from the applicant under this contract or not. This payment is independent of the fact whether if this contract allows any alternate medium to the beneficiary to claim payment. So for example, if the contract says that the beneficiary also has party C to whom the beneficiary can approach and claim the damages. So this payment which will be made by the issuer to the beneficiary is not dependent on the fact whether beneficiary goes and claims from any third party or not. And the last one, this payment is not dependent whether applicant has actually performed or not. If beneficiary is submitting credit compliant documents or SBLC compliant documents, I will make the payment. So we have seen standby is irrevocable and standby is independent. Third is standby is documentary in nature. Documentary in nature means beneficiary to claim under the standby will present SBLC compliant documents. Bank will be making payment only on the basis of face value of these documents, whether these documents are complying with SBLC terms or not. Bank will not look into whether the actual performance has been made or not, or whether the actual genuineness of the facts mentioned in these documents. If on the face of it appears to be genuine and complying with SBLC terms and conditions, bank will make the payment. Next is SBLC is a binding undertaking. What do you mean by binding undertaking? The issuer is bounded by the SBLC terms and conditions the moment it is issued. It does not matter whether applicant has authorized the issuance of this SBLC. What do I mean by this? Suppose applicant requested with these terms and conditions, but when it was ultimately issued, the amount got changed because of a typo error at the issuer's end. The undertaking was issued for $200,000. The issuer is binded by this undertaking even if applicant did not authorize issuance of such kind of an undertaking. So the loss which issuer will be bearing is issuer will not be getting reimbursement from the applicant because the undertaking was issued incorrectly. However, issuer is binded by this undertaking because it has been issued as an SBLC subjected to these rules and subjected to the fact that if beneficiary presents a compliant demand, it will be paid. Next is this issuance is not dependent on the fact whether applicant has paid the commission or not. Suppose this undertaking was issued correctly for $100,000 and as per the specifications mentioned in the application. It does not matter whether the relevant commission was paid by the applicant or not. Third, this undertaking will be valid even if the beneficiary has not received it. The moment it is issued, the issuer will be binded by this undertaking. Next is 1.07. 1.07 deals with issuer and beneficiary's relationship. What it says that this SBLC is a link or is a contract between the issuer and the beneficiary. It is independent of any other relationship which might exist between the issuer and the applicant. So what do I mean by this is, if suppose issuer has some other payments or some other commission which is to be received from the applicant. Okay, applicant is suppose has not paid some prior dues from some other undertaking to the issuer. Issuer cannot say that since you owe me some money, I will not go ahead and make payment under this SBLC. No. If a complying claim is received, if the documents are submitted by the beneficiary complying with the terms and conditions of the SBLC, irrespective of what is happening between these two, that will not affect this undertaking. This is meant by the undertaking which is issued to the beneficiary is independent of any other relationship. Alright. Next is 1.08. 1.08 deals with the limitations to issuer's responsibility. What it says, number one, this SBLC is the basis of issuance of this SBLC is this contract. I am not responsible if the performance of the applicant under this contract is not as per the terms and conditions of the contract. If there is a breach in the underlying contractual obligations, I am not responsible. I am only responsible if you, beneficiary, presents a compliant demand or compliant documents my responsibility is only to pay. I have nothing to do how applicant is performing in the underlying contract. Secondly, if this document is presented, I am not responsible if this document is not genuine, if this document is not accurate. If on the face of it, it appears to be a genuine document and it appears to be complying with the SBLC terms and conditions, I will go ahead and make the payment. If any wrong thing happens wherein this document is found to be forged, and when it was presented to me, the physical appearance of that document did not give any indication to me that it was a forged document, I am not responsible. Next is action omission of others. Issuer is not responsible for act of any other party, be it advising bank, be it nominated bank, or be it confirming bank, or any other party which is used by the issuer to give effect to this undertaking. If any of them do not perform according to their responsibilities, issuer is not responsible for it. Okay, and the next thing is, suppose this SBLC is issued wherein the applicant is in country A, issuer is in country A, beneficiary is in country B. The undertaking is subjected to laws of country A. This is law. Alright, what SBLC says, the issuer is not responsible for observance of law or practice other than that chosen in the standby. The law chosen in the standby is of country A. Beneficiary resides in country B, wherein law of country B is applicable. If because of this law some elements of this undertaking are being changed, because some countries might have that if any undertaking is issued to my country law will prevail, irrespective of the fact to whichever law that particular undertaking is subjected to. Which means, if this SBLC is subjected to law of country A, law of country B imposes some regulations which modifies the terms and conditions of this undertaking, issuer will not be responsible for that change. Okay. Next is 1.09. 1.09 deals with few definitions. So let's look at those definitions. First is applicant. Applicant is the entity which gives the request for issuance of standby, or who is issuing the standby on his own behalf. It is also possible that a standby is issued by a company. Many corporates have access to SWIFT systems, and those corporates are capable of issuing MT700, which is LC, or MT760, which is guarantees, and they issue these undertakings on their own behalf. So in those cases they will act as applicant as well as the issuer of the undertaking. So in this case, in these rules, applicant means either an entity who is giving the request to issue SBLC, or an entity who is issuing the SBLC on its own behalf. So for example, in this case, if the bank issues the SBLC on its own behalf, then bank will act as an applicant and the issuer. Next is beneficiary. Beneficiary means the party who is allowed to draw under the standby, which is company B in this case. Next is business day. Business day means any regular day when on which date you are open for regular business. If you are regularly open from Monday to Friday, then only Monday to Friday will be considered as a business day. Okay, next is confirmer. So like an LC, an SBLC can also be confirmed. So in this case, applicant will give the issuance request, bank X will issue the undertaking to bank Y, bank Y will add confirmation and send the undertaking to the beneficiary. The moment confirmation is added, bank Y steps into the shoes of bank X. So the beneficiary can present demand either to bank Y and bank Y will make the payment, or to bank X, wherein bank X will make the payment to the beneficiary if the demand is complying with SBLC terms and conditions. Next, before going to next definitions, let's look at an example. Suppose this SBLC is calling for number 1, demand, number 2, a copy of invoice. Okay, now first is demand. Demand means, depending on context, either a request to honor a standby or a document that makes such a request. So if these two documents are collectively presented under the SBLC, it will form a demand, because these two, when they are together presented under the SBLC, will comprise of a complying presentation. Next is document. Document can mean presentation of any of the documents which are called for under the SBLC. Next is drawing. Drawing means when a complying demand is presented under the SBLC, it is called a drawing. So when these two are presented and both of them are complying as per the SBLC terms and conditions, then collectively it will be termed as a drawing. What is an expiration date? Expiry date is the date on or before which demand has to be presented to the issuer, or documents complying as per the SBLC terms and conditions are to be presented to the issuer. Now person. Person includes any entity which is forming a part of the standby, or which is being used, or which is being mentioned in the standby to carry on some particular task. Any entity will be termed as a person. Next is presentation. Presentation is the act of presenting any of the document. So presentation would be, suppose invoice is presented to the issuer, this act will be called as presentation. Okay. Next is presenter. Who is submitting these documents will be termed as a presenter. Presenter can be beneficiary's agent, presenter can be a courier company, presenter can be beneficiary himself. So whomsoever presents these documents to the issuer is termed as a presenter. Next is signature. Signature means an intent should be visible that the entity has tried to sign the document. Signature can be perforated, it can be in form of stamp, it can be handwritten, as what is required in this undertaking. Alright. Now there are few more definitions which are cross references, which we will see as and when we see that particular article. So friends, here we complete our training session. I hope you liked it. If you liked it, please press on the like button. Have a great day. Thank you.